Happy Thursday, everyone. I am Anna Hobson from HR Simple, and I will be moderating today. We just have a couple of housekeeping announcements before we get started. Today's webinar is in partnership with Ogletree Deakins. Ashley will be answering questions throughout the webinar, and if not at the end. If you do have any questions, please submit them in the question box, and I will be forwarding those over to her. If you'd like to see more COVID-19 webinars from our partners like Ogletree Deakins, you can go to hrsimple.com/events, and we have dozens of webinars posted from great reputable resources. HR Simple provides state and human resource manuals with up-to-date COVID-19 information. We do work with state chambers and great law firms like Ogletree Deakins, and today you can use code COVIDwebinar40 at hrsimple.com to receive 40% off any purchase. So now we're going to go in and learn a little bit about Ashley before we get today's presentation started. In response to the coronavirus pandemic, Ashley has led Ogletree Deakins' nationwide unemployment response team. In this role, Ashley tracks unemployment changes nationwide and provides counsel to clients on unemployment-related issues. In addition, Ashley is the co-chair of the Ogletree COVID-19 Litigation Practice Group. Outside of coronavirus, Ashley concentrates her practice in management-side employment litigation, including defending claims against wage and hour, discrimination, wrongful discharge, and breach of contract. Ashley's specialty is complex litigation, class actions, and multi-plaintiff litigation. So on that note, I'm going to hand things over to Ashley so we can go ahead and get started.
Thank you so much, Anna. All right, I should have shared my screen. Anna, can you confirm it's shared?
Yes, it's shared full screen. It looks great.
Great. Well, thank you again so much for having me today. Again, my name is Ashley Cuttino, and I am in Greenville, South Carolina, but I work for Ogletree Deakins. We are the third largest labor and employment law firm in the country, and we have offices in all of the different states as well as some international offices. So for those of you listening, we'll be talking about some things that may be state specific and other items that if you are a multi-state employer, we'll be talking about those issues too. So when Anna contacted me about doing this presentation, what we really thought about was that it would be good for us to kind of go through what we here at Ogletree are seeing is the top 10 coronavirus questions that we're giving right now. So this presentation is as up to date as I could make it. And what I've tried to do is really go through what are the top questions that we're getting about COVID-19 coronavirus from the HR community. And as Anna said, I'm glad to answer questions as we go along. So please do type them into your question space, and I'll either answer them as we go along or I'll try and get to all or most of them at the end. So let's just dive right in. So I think one of the top questions that we've gotten as different communities around the country have reopened goes along this lines. You're an employer, you have sent most or all of your folks home to work, and now you're reopening your working environment. You're bringing people back into the workplace, but you have some employees who don't want to come back, and they've requested to be able to continue to work from home. And the question we get is, do you have to allow an employee to continue to work from home? The simple answer is no, but. So there is no right to work from home. However, in the coronavirus environment that we're living in, you have to look at beyond if there is a right to work from home. So the most frequent reason that you would allow someone to continue to work from home would be if it's some kind of disability accommodation that you need to make. For example, you have folks who are high risk and they fall into those high risk categories, or they have some other disability that makes it important for them to continue to work from home. In the past, you would have done the normal evaluation for an ADA claim. You continue to do that same ADA analysis in this situation now with coronavirus, but I think it's important for employers to think about the fact that it is going to be very difficult for an employer to argue a hardship issue as long as you have been able to successfully have your folks work from home for several weeks or several months. It's basically just a continuation. So if the person has an accommodation need, that would be one of the reasons that you would want to allow them to continue to work from home. We also see this with folks with school-age children, that they want to continue to try to work from home while being at home with the kids with childcare issues. That is also a reason that we're seeing people allowing the continuation of the work from home environment. So while there's no right to work from home, there are other reasons why continuing to work from home may be what your company wants to do. I will tell you all that we have many clients who are wholesale changing their operational structure such that to the extent they have people who can work from home, they're going to allow that for a long time, if not permanently, because they've realized with technology, they can do it. So you have to also think about your public relations issues here as far as your employee relations. But at the same time, we've also have clients who've run into an issue where everybody else comes back to work except for that one person who won't come back. And an allowance is made to let that person continue to work from home. And then that person is all over Facebook, because they have so much free time now. So you do have to manage it. But when you ask me do you have a right to work from home as an employee, that base answer is no. And then you have to consider whether or not any accommodations are needed under the ADA or the FFCRA for childcare issues and or your employment relations reasons. So one of the other big questions that we are getting now has to do with pay for temperature or health screenings. As so many of you have opened back up, you are doing some kind of health screening. Most of you are doing it on a daily basis. And the question is, do you have to pay for that? There is not a great straight answer to this. It really depends on several factors. First, it depends on who's performing the screenings. So are you having people do a quick self-check at home? Or are you having a nurse or someone on site at the facility do it? Second, where does the screening occur? Again, is it an at-home screening or is it an on-premises screening? But really one of the most important questions is, how long is the screening taking? The real issue is under the FLSA, does it fall into the de minimis exception? And that depends on what kind of screening you're doing and how well you're doing it. For the most part, if you're asking someone to do a quick temperature check at home and fill out a quick survey that takes, a minute, that's probably not compensable time. But if you're doing an on-premises screening where people are having to wait in long lines to get into a plant or facility, then you may be beyond the de minimis exception. It's also important to note what state that you live in. All of this issue falls under the FLSA rules for kind of donning and doffing, and different states have had different rulings in that area. If you're in California, you have a very high risk of these claims happening. And in fact, we have seen many of these claims that are currently pending before the California courts. So in California, I would encourage you to be exceedingly cautious and really talk to someone about the risk of not paying for this time. In other states, there seems to be less risk, but you really need to think through how you're doing the screenings, where you're doing the screenings, what is the purpose of the screenings, and how long does the screening take when you determine whether or not you're going to pay for temperature screening time. Again, in most scenarios, this time is not considered compensable. There is some risk to that, but again, you need to go through and really understand how you're going to have these health and temperature screenings done, and is there a way for you to make them efficient enough that they take the smallest amount of time possible. So the next big issue we have is the FFCRA and kids at school. So for those of you who are covered by the FFCRA, I'm sure all of you have heard a million webinars, tools on this by now, covering smaller employers under 500 and government entities. One of the biggest issues we've had with the part of the FFCRA about COVID and kids at school are hybrid situations. So these are the situations where you have employees whose children are going back to school maybe on Mondays and Wednesdays or Tuesdays and Thursdays, but the other days they are at home. How does the FFCRA apply to those folks? Well, the Department of Labor has come out with some guidance for us on that question. And what they have said is that if the school is not accessible to the child, then the person is eligible for the paid leave under the FFCRA for that day. So for example, if my children go to school on Monday and Wednesday, but they are at home doing virtual learning on Tuesday, Thursday, and Friday, then I as an employee would be eligible for the FFCRA paid leave on Tuesday, Thursday, and Friday. Those are the days that my children are virtual schooling and there is no ability for them to go to school. On Monday and Wednesday, I should be reporting back to work virtually or in person, and it is not time that I can take FFCRA. The same thought pattern applies if you have employees who are in a school district where choice was given. So where I live, we had the option of putting our children 100% in virtual school. Under the DOL guidance, if I chose virtual school for my children, I am not eligible for the FFCRA because I made that affirmative choice. I have the option to send my children to school. School is not closed for my children. I made the choice not to send them, which I can do all day long, but school is not closed. So that's one of the big issues that we have. And if you're applying the FFCRA and this kind of paid leave to your employees, I think it's really important for you to remember that the FFCRA is an adder to the FMLA, right? So it gave you different criteria for why you could be considered eligible for the FMLA, and it gave paid leave for these specific reasons. But otherwise, when in doubt, you follow the rules of the FMLA. So when you have someone in a hybrid situation, it is essentially like intermittent FMLA leave. So it doesn't have to count every day, but you do count the total as you go along. One of the other really big questions that we're getting right now is, can an employer make an employee get a COVID-19 vaccine to return to work? So I think we all know that a vaccine is coming. Whether we get one by the end of the year or early next year, I think is anybody's guess. But a question is already starting to come up, and employers are already starting to think about, well, when the vaccine does come out, are we going to make our employees take one? And the answer to that is we have to look at what happens with the flu vaccine, and we have to look at what happened back when we had SARS a couple of years ago. So if you're a non-governmental employer, the fact is you can make employees take a vaccine to return to work, with a few exceptions, of course. So if you're non-governmental, there is no kind of constitutional right not to take a vaccine and keep your job. Now, you have a right to quit your job if you don't want to take the vaccine. That's fine. The employer can say, you must take the vaccine to come back to my premises. However, that is really not the recommended course. So there are several exceptions to that. And it's much like the flu shot. So we already have this question come up every year with the flu shot. Normally, we only see it in the healthcare arena, though, because normally it's only in that healthcare arena where people really say, we're going to mandate that you get a flu shot every year. The exceptions that you have to make, though, are if someone has a religious opposition to taking a vaccine, you have to accommodate for that. Also, if anyone has any kind of health issues, you have to make an accommodation for that. There are some people, because of health issues, that they can't take a vaccine. One of those is an egg allergy, but there's several others where there are disabilities where they cannot take a vaccine. So you have to make religious accommodations, you have to make medical accommodations. And then what we've seen as a result of SARS, there are also some states that when SARS came out, they said, we're going to pass some temporary rules that you cannot make someone take a vaccine if they have moral or ethical objections. We anticipate that when the COVID-19 vaccine comes out, this is going to become a really big issue. And it will not surprise us at all if some of the states make some declarations or even issue some orders that you cannot make someone take a vaccine and come back to work if they have a moral or ethical objection to doing so. We're going to have to wait and see what happens with that. But again, that happened before, so we do anticipate it coming. What is suggested as a best practice instead of a mandate for a vaccine is for employers to think about whether or not they will pay for the vaccine for their employees, and then to make really more of an informational campaign about why the vaccine is good, why we want you to take it, and what are the reasons why it's going to be beneficial for your workplace. So when you look at whether or not you're going to mandate an employee take a vaccine, you really need to come up with your reasons for why do we think it's important for employees to get vaccines at our workplace. Do we have a workplace where we can justify mandating this kind of requirement? Or do you have a workplace where you've arranged it so there's very little interaction between your people? Where I am, I'm currently in my physical office today, right now, but I am in a closed office. My door is closed. We have procedures in place here where we only have one person in a bathroom at a time, one person in a break room at a time. I am very rarely seeing other coworkers in person. Now, for some of you in a manufacturing facility, that's just not your reality. So you may have different issues to consider there. But an informational campaign where you even have people come into your workplace and give the vaccine, but it not be mandatory, is really what everyone suggests as a best practice in this area until we know more about the vaccine. A big part of this too is from an employee relations standpoint, the current polls say that just shy of 50% of people are not sure that they want to get this vaccine as soon as it comes out. You're also going to have the issue that even when the vaccine comes out, we know that there is not going to be a nationwide supply for everyone to get a vaccine. So before you considered putting some kind of mandatory policy in place, you would also need to be able to make sure that you actually have access to be able to get the vaccine. You certainly don't want to put a mandate in place if people actually can't get the shot itself. And it's anticipated that it's going to take several months for it to be widely available to those Americans who are not in the high-risk category. So those are things to think about, but I would encourage you as HR professionals to begin to consider what your rules and policies are going to be about a vaccine and really to think about it. At the end of the program today, I'm going to give you some resources. We have some really good blog posts that really talk through all of the different issues surrounding mandatory vaccines and talking about the best practices and the things that you should consider. And I would encourage each of you to look at those as you start thinking about what you're going to do with vaccine use in your employees in the future. One of the other really big questions we are getting a lot is about state leave beyond just the FFCRA. So as you all know, the FFCRA was passed, but we've also now had multiple other states and or cities who passed their own leave laws that may be the same and mimic the FFCRA, or they may be a little bit different. So you really need to go and have a good handle on what the leave laws currently are in your jurisdiction. Just this week, we've seen some changes to some of these in Pennsylvania and in California. We know some more are coming out. One place that you can go to specifically check what the rules are in your area is, again, Ogletree has a free coronavirus resource page that we have up, and you'll have the link to that here at the end of the slides. And there is a little button on the right-hand side that says State and Local Orders and Resources. Under that tab, it will give you a listing of all of the paid leave requirements and tell you what they are. So for example, if it's only a certain city within a state, it will tell you that. So it will give you all of those different states and locations that have specific paid leave laws right now and what they are. And we update this at least weekly. We try to update it as soon as they come out. So it's a really good resource for you to go and look at. All right, so we have a question that's actually come up about the FFCRA. So when you talk about how you count the FFCRA leave, it is 2 weeks or 80 hours for the paid leave if you are sick with coronavirus or you're caring for someone who's sick with coronavirus. That's the Emergency Paid Leave Act. And then we have the Emergency FMLA leave, which is the leave that is paid if you are caring for a child who no longer has access to school or daycare. So the amount that you pay someone under each of those scenarios is different. If the person who is getting FFCRA leave is the person who is sick, they have the coronavirus, then they get paid at their full rate of pay up to a cap. If they are caring for someone with coronavirus, or if they are caring for someone, for a child who can't go to school or daycare, then they are eligible for up to 10 weeks of paid leave, plus at a rate of 2/3 their regular rate of pay, capped at $200 a day. Now it's a little tricky because if you are caring for someone who's out of school or daycare, you first get the paid sick leave 2 weeks, and then you roll into 10 weeks of school care FMLA for a total of 12 weeks. But under either of those scenarios, you are caring for someone, so it's capped at the 2/3 or $200 a day. All FMLA is not paid. Those rules have not changed. The only portion of FMLA that is now paid are these 2 individualized special FFCRA forms of FMLA leave. Again, those are the emergency paid sick leave. That's you're sick with coronavirus or you're caring for someone who's sick with coronavirus. Or the new emergency FMLA leave, which is only if you have a child who cannot go back to school or daycare because that school or daycare is closed to your child for in-person instruction. Any other type of FMLA is still unpaid, but the rules stay the same. This is an additional qualifying reason why you would qualify for the FMLA. This is emergency FMLA. And if you have detailed questions about how to count the hours, one of the questions we got was how to count the hours. Again, on the Ogletree Deakins coronavirus page, you can go to the tab that says FAQs. We actually have 50 frequently asked questions just about the FFCRA. It helps you count your hours. It helps you count your people. It answers the questions you have that are specific as to going back to school and when you should and when you should not use the FFCRA. So again, when you look at the FFCRA, it is only those who have less than 500 employees and or they're a governmental entity. With that said, we have multiple states and or individual jurisdictions within those states who have passed some form of paid leave. And again, you can access, these are the states where either the state has done it or some jurisdiction within the state. So you need to go and look at this particular order about paid leave if you operate in any of these states. All right. Another big question we've gotten is, how will an employee prove that they got COVID at work? And how will my company be liable if they say they got coronavirus while at work? This is a very complicated and convoluted question right now. So prior to COVID-19, any injury at work would be covered by workers' compensation. You all know that. It's fairly clear that COVID-19 is not an injury. However, whether or not it is considered an occupational disease that was contracted at work is a different question. That is the criteria under which COVID-19 is going to be considered a potential workers' compensation claim. So what has happened is several states, in response to COVID-19, have actually passed either legislation, executive orders, or their workers' compensation agencies, whatever that is in the state, have come out and they have said that we're going to make it a presumption that if an employee gets COVID-19, that they got it at work. This state map that you see here shows you which states have already made that decision and which ones are pending or in process. Now, for these states that are making the presumption that an employee got COVID-19 at work, then the question is, what does that mean? So that means when you go before your workers' compensation agency, pre-COVID, the employee had the burden of proof. Now, for a COVID-19 claim, the employer is going to have the burden of proof that the employee did not catch COVID at work. So there's going to be an assumption and a starting point of, yes, the employee got COVID at work. And then the employer must prove no. That, in some ways, is going to be easy and or difficult depending on your fact scenario, right? So maybe you have folks who are still working from home. That will be pretty easy. Suppose you work in a workplace where you've had no other positives, but you're able to show that the employee's child had COVID and the child went to a birthday party where everybody at the birthday party had COVID. You'll be able to show that. But in many cases, it's going to be very difficult to be able to tell where a person got COVID. It's going to be interesting to see what other legislatures do as they come back. For example, in South Carolina, we have this bill pending, but our legislature has dismissed and will not be back until January. When most of these presumption rules were passed, they were passed at the point in time when the whole country was essentially locked down. And so people were really only going to work, or that was what they were expected to be doing. So when these rules were passed, that seemed like the logical place where you would get it. But now that the country is opening back up, that is going to become much more problematic. But again, in areas where a presumption rule has been made, I think it's important for you to realize that it's going to be up to you, the employer, to prove the person got COVID somewhere else versus the burden of the employee to prove they got it at work. All states have not passed this presumption, but some have. We also see many of these claims so far, they're being filed in state court, not in the workers' compensation forum. So they're filing, plaintiffs' attorneys are filing these claims in state court, and they're making an allegation that the company has exhibited gross negligence in regards to their health and safety rules. They are doing that because almost all states have a workers' compensation exemption if the employee is grossly negligent in putting an employee in an unsafe work environment. The reason they're bringing those claims in state court is because if they use the exception, they're not subject to the caps that you have in workers' compensation. So what employers are doing in all of those situations is they're moving the case back to the workers' compensation arena if they can. So the issue is, was it contracted at work? And then if the answer is yes, you have caps, or you try to actually prove that no, they got it somewhere else and it wasn't at work. But knowing what your state's rules are regarding the workers' compensation issues is going to be one of the biggest areas of litigation that we see coming up. This is one of the big areas where we're seeing a lot of litigation be filed. Again, on that same coronavirus resource page that I told you about earlier, we actually have a tracking system that will tell you exactly what each state has done in this area. Because for some states, they've only said the presumption applies to healthcare workers and first responders. In other states, they're applying it to essential workers. In some states, even where they have the presumption, they're applying it to all workers. Each state has been very different in what they've done in response to the coronavirus and workers' compensation. And many of these, they even have a presumption, they are short term. So in fact, in California, they actually had a presumption for a while. That order expired, and now there's another order pending that we expect to pass because they have passed it before, it just expired. So one of the other big questions we get is, has Congress passed any protections from litigation in the areas of human resources and employment? Or what about the states? So the answer to that is kind of, but not really. So Congress has not passed any kind of overarching liability protection. That kind of idea was part of the Senate bill number 4 that was voted down. And it is part of what is being negotiated now in Washington, D.C. I will say at this point, I don't think anybody has any idea what's going to happen in Washington, D.C. You know, just this week, Trump said he wasn't going to negotiate anymore until after the election, but it seems like talks have resumed. But getting any kind of meaningful liability protection for employers, for your employees, I think is going to be far-fetched, and it's not going to be what employers want if they get it. So when you look at this map, these are the different states that have passed some kind of liability shield legislation. Liability shield legislation is the term that we lawyers use for laws that have been passed that shield an employer or a business from liability. When you look at the states that have passed liability shield legislation, even those that have passed it, it is limited from an HR perspective. Most of the liability shield legislation we have seen goes to covering the medical community from malpractice claims for treatment of COVID-19, to the makers of products who are using new products to defeat COVID-19, so from product liability type claims. And then to the limited extent that we do have any kind of HR liability, it does not cover claims for workers' compensation, and it does not cover claims for gross negligence. So to get around these shields, if a claim is about you got sick with COVID at work, those are exempted. And also any claim that says the company acted grossly negligent in some area are exempted. So when you take those two questions out, you really don't have very much coverage left from an HR standpoint. That is the same reason why some employers are using COVID-19 waivers, but many have chosen not to. If you decide to use some kind of COVID-19 waiver with your employees, you legally cannot ask an employee to waive their rights to workers' compensation. And even if you do and it gets signed, it will not be enforceable. Similarly, you cannot have an enforceable agreement that asks an employee to waive some kind of gross negligence. So when you take those two claims out, then what you're really waiving away is pretty limited, if anything at all. Another issue with the waivers that we've seen is that if the employee is currently employed and you just ask them to sign a waiver to continue their job, in most states that will not be enforceable because you have not given any kind of additional consideration. So that's another big issue with those waivers that rolls right up in with the liability shield legislation that we're seeing, is that from the perspective of the HR community, they're fairly limited in what kind of protections they are actually giving to the business community as far as litigation from their own employees. So I think the number one problem that the HR community is having right now is how to keep up with various state law changes, agency changes. It has been an onslaught of information for everybody. You heard at the beginning where Anna was talking about the amazing resources of HR Simple. We here at Ogletree, again, do have our COVID-19 Resource Center that has blogs on almost every topic you could ask us on, frequently asked questions on these top areas. They're all free to clients to use. This is the resource for our frequently asked questions. But what's important is, like in HR Simple, you need to find a trusted partner that resources that you know are updated. We're facing a situation right now as HR professionals where sometimes the updates that are being made are being released by some state agency over Twitter. It is overwhelming to try to track them all, especially if you are a multi-state employer. If you're not multi-state, or if you are and you want to start tracking things yourselves, the top resources that you should be tracking are the CDC, OSHA, the Department of Labor, and all of those have a place where you can go onto their website and you can sign up so that you get a dinger when they issue something new. You should also be following your state OSHA agency, whatever that is, as well as your state Department of Labor and your state unemployment agency. Those are the top 6 things that you as an HR professional should really be following right now to stay up to date on the newest changes. Or again, it's finding a trusted partner that helps consolidate all of that information for you so that you have less to go through on a daily basis. So what's next? When people ask us what's coming next, it's a very simple answer. What we're going to see next is all of the litigation that comes out of COVID-19 and the coronavirus. We've already seen plaintiffs' attorneys who are on the hunt. They're actively advertising on TV and social media. We're starting to see commercials in some areas. We're seeing an increase in class action, and we're seeing an increase in litigation regarding the return to work from when everything was shut down. Here are just some of the headlines that we've seen lately in the news. You've all seen them too, some of the big stories about the big litigation that is starting to be filed around the country. But one thing that's been really interesting is that we have seen different things come out from plaintiffs' attorneys trying to solicit clients. And a lot of this is being done online for the first time. And it's been really interesting to actually see how people are responding. And we're seeing more and more comments where it is not favorable to the plaintiff's bar. It's going to be very interesting when we get to trials on these issues if this sentiment continues. But we do not see a lot of positives for the plaintiff's bar in regards to the coronavirus claims that they're making thus far. But when we look at the claims that are being made, the current employers that are being targeted from an industry perspective are healthcare, manufacturing, retail, and kind of essential services. When you think about it, this makes sense. Most of these industries, healthcare did not shut down. Our manufacturing and essential services, they did not shut down. So those 3 industries are the first ones that saw claims. and they are still the highest in the number of claims that we're seeing. Most of their claims have to do with whether or not the employer is providing a safe workspace in regards to COVID-19. Is the employer giving the proper PPE? Are they cleaning? Are they quarantining their employees? Are they doing the things that they should be doing to keep their employees safe? And it's a very challenging environment right now for employers in that regards, because as we all know, all of us have our own individual tolerance for risk when it comes to COVID-19. And so there are always those employees who believe you're not doing enough, and there are those employees who believe you're doing too much. And employers are getting hit with litigation from both directions. I have one client right now who is dealing with complaints that they are mandating a mask policy, and at the same time they're getting complaints that the mask policy is not strong enough. So they're getting complaints from both sides. We're also seeing a lot of claims from what I'm going to call the retail industry, as well as the hospitality industry. Most of those claims have to do with the layoffs that have occurred and the job losses that have occurred, which are now, unfortunately, many becoming more permanent. And those claims have to do with, why did you pick me for the layoff over someone else? They are based in discrimination. But we are seeing these things, these litigation files expand to all of the different retail areas. Again, the number one claim we're seeing are whistleblower and retaliation claims. Those claims invariably go with the unsafe working conditions or the workplace safety claims that we're seeing. They're all rolled up in one. They're making different causes of action, but they're all the same general claim, which is, I complained that I did not think the workplace was safe enough, and now I've been chosen for layoff, or I've been terminated, or I was given a negative work write-up. We are seeing that in the vast majority of the claims we're seeing right now. They all have to do with claims of an unsafe work environment, and then a whistleblower claim and a retaliation claim going with them. We're also seeing claims having to do with WARN or COBRA. So when you did your layoffs, those are layoffs that just hit like a bomb in March and April. Did we do them correctly? Did we give the proper notice under unemployment laws? Those kinds of claims. There are a handful of WARN claims that are currently going through the courts right now. We do not have a ruling yet for any WARN case to tell us definitively if COVID-19 falls into the WARN exceptions. So we are watching those cases very closely. We're also seeing an increase in claims under Title III for disability access into a public space, so a grocery store, a retail establishment, those kinds of areas, as well as Title VII discrimination claims. Most of the claims we're seeing are disability-related claims, and they have to do with somebody says I have to wear a mask, I can't wear a mask because I have some condition that prevents it. Or I have some other disability and so I need an accommodation, and were you or were you not willing to give that accommodation? Those are the top claims that we're seeing filed across the country. The other big area that we're seeing has to do with wage and hour claims. Again, are you properly paying for the FFCRA? Are you properly paying for any kind of leave under any kind of state law? Those are the majority of the claims that we are seeing filed. So again, this is kind of a common claim that we're seeing. The employer allegedly fired the plaintiff after he notified the employer of an exposure to COVID-19. That's very common. A hospitality employer allegedly did not install a plexiglass shield, and the employee thought that plexiglass should have been mandated. Those are very, very common claims that we are seeing right now. An employer placed a pregnant plaintiff on furlough during COVID-19. And then the question was, did they choose that person for furlough because of their pregnancy, or because of some other reason. So when you look at the cases that we're seeing, as you can see, in March, we started having a few, and they have just exploded over the most recent few months. For some background, for a while there, we were seeing claims really drop off in the employment area. Courts were closed, the EEOC was closed for a while, and so claims had fallen off. We are now back to a level where we're seeing the same number of lawsuits that we did before, but now we're actually seeing an increase in those claims because of COVID-19, and we're seeing COVID-19 being a large percentage of those claims that are being filed. Again, this just kind of gives you a visual of what I was talking about before, and you can see retaliation is one of the biggest areas that we're seeing claims. When you look at health and safety, you should also combine that with working conditions. They are very much the same claim, and so that piece of the pie is a little bit higher than what it looks like there, but that just kind of gives you an idea. We do expect the area with the biggest growth to be the Title VII discrimination claims. So I think most of you probably know this, but if you don't, so for 4 months, the EEOC was not issuing plaintiffs right to sue letters. They have now begun to reissue right to sue letters. So we have seen the most dramatic increase in the last 3 weeks in discrimination claims being filed, and we expect that to continue now that the EEOC is actually processing their backlog. We can also show you where the greatest number of claims are being filed. Not surprisingly, you see bigger numbers in states where you have more population. We also see bigger numbers in some of the states that have had bigger lockdowns as far as where the claims are being filed. So what should you do to prepare for 2020 in the fourth quarter and next year? So the biggest and most important thing I can tell you is something that all HR professionals know, but I want to phrase it a little differently this time. So whenever you're making decisions with your business units about what you're going to do and why you're going to do it in relation to COVID-19, it is very important that you document when that decision is made and why the decisions were made. So if you are relying on an order that your governor issued, make sure you reference that order in your notes. And more importantly, if you have a copy, stick it in the file. What we're seeing now is that employers who are having to defend these COVID-19 claims are having to go back and recreate when the decision was made, because what we have to do is say, okay, this decision was made on April 10th. On April 10th, this is what the CDC was telling us we should be doing. And that could be very different than what the advice is today, because we've learned so much more about this disease that the advice has changed. And so it's not just who made the decision, but when the decision was made and what, kind of government order or recommendation you are relying on at that time. And I think we should all be very accepting that none of us know what is coming next. And so we're going to have to continue to make these kinds of decisions into the fourth quarter and into next year. I think all HR professionals should be really up to speed on those leave laws that we talked about and the paid leave laws, especially as we move into flu season. We're going to have a lot of people who are sick with the flu, but we have to make sure they're not COVID positive before we can let them in the workplace. Same thing with kids in schools. I think you should anticipate higher absences from your working parent population this fall and spring, as people have some kind of, just normal respiratory virus, but they cannot go back until they know they're COVID free. That actually happened to my child already. He has horrible seasonal allergies every year. He is going to school 2 days a week, virtual 3 days. He went to school one day and apparently proceeded to sneeze all over the classroom. Teacher freaked out, principals freaked out. They shut down the classroom. They sent everybody home, and it was just his allergies. Somebody said at one point in time, flu and allergy season this year is going to be like the Blair Witch Projects. And, I think to some extent that might be true. And so you're going to really need to have a plan in place for how you deal with that, because you're going to have to explain to your internal stakeholders what you have to do to comply and what kind of unique accommodation and leave requests you have been getting and are going to continue to get. And again, making sure you understand what's going on in your jurisdiction. Where I live, we have 5 different school districts that kind of feed into our major hub of employment, and they're all doing different things. None of them are doing school the same way. So you really need to be thinking about those kinds of issues so that you can stay up to date on what your employees are having to deal with. And again, it's important to remember that despite COVID-19, it is not the only thing that's going on from an HR perspective. All of the other things that you had to deal with before COVID-19 and all of those rules are all still in play right now. So don't forget the basics of COVID-19 and keeping up with the COVID-19 issues and trends and what is going on outside of COVID-19 is still very important. So we do have a couple of questions. And so question 1 is, do employers have to reimburse employee expenses related to their remote work? So it depends on what state you're in. In California, you have to pay for most things. Illinois is another one where more portions of remote work have to be paid for. But the general answer is this: you must pay for the equipment that someone must have to do their job at home. So for example, at my work, I all the time have a laptop. I was allowed to take that laptop home with me to do my work. As I sit here in my office right now, I also have 2 different screens up. So I have 3 screens that I use on a daily basis in my office. I don't have to have those other 2 screens to do my job. I like having them. When I'm here in the office, my office is willing to pay for them. They do not have to pay for me to have 2 screens at home because I do not have to have them to do my work. They do have to provide me, though, with a laptop or what I need to actually physically perform my duties. Now, if you don't want to provide a laptop and you're having your employees use their own computers, then you have to start thinking about things like, how are we going to pay for the internet? Are we going to pay for the internet? That depends on whether or not you have anything special that is required above and beyond what the employee had before. So you do have to pay for some things, but not everything. One of the things that we've done here is when we leave, we all took a go box with us where our office support staff put together for us staples and pencils and pens and packets of paper for us to take home to be able to use. And if we need more, they will send it to us so that we can still get volume discounts on those types of things that we need and we use for work. But some jurisdictions, again, California is a big one. If you're having someone use some portion of the internet, some portion of their data plan for work, then you should be reimbursing them for that amount. You can do that through an actual count how much they used it, or you can take a reasonable percentage and pay someone, say, $20 a month, $50 a month, depending on what the use looks like. As a result of COVID-19, we are seeing more and more employers either providing phone plans and or providing actual devices to employees. One of the big issues we've seen with working from home is data security and data safety. And if you're having someone use their personal devices for work, it is much, much, much harder for you to control things from a data security standpoint. So hopefully that answered your question. I will be glad to dive in further if we need to, but we have another one. Okay, so if you have an hourly employee who's working remotely during COVID-19 and you're allowing for some kind of flexible work arrangement for when they are doing their family obligations, you need to pay for the time worked just like you did before. If you're allowing for flexibility, you need to come up with some kind of way for them to sign in and to sign out of work so that you can ensure that you're paying for all of the hours that they're working. And so whether you can do that electronically or manually, you need to pay them for the hours that they're working, but if they're hourly, you do not pay for the hours they don't work. So it's just like before, but it's harder to track now because they might be taking, you know, an hour off in the middle of the day to go pick up the kids from school or whatever it is they need to do. One of the big problems that we've seen in one of the areas of litigation we're expecting has to do with the payment to remote workers. We've seen, I think, through this kind of two types of people. There's person one who has trouble motivating at home, or maybe it's not a motivation issue, it's a childcare issue. It's, you know, they're in and out, up and down. They need lots of flexible work to be able to get things done at home. That person's hours can be hard to track. And then we have the person who's going the other way, which is the person who kind of can't turn it off because their computer is right there at their dining room table or right down the hall. They don't know how to walk away from work at 5 o'clock or 5:30. And so they're working all night long on things. And so you need to make sure you're capturing your hourly folks' true work hours, and you need to put in procedures and processes for don't work overtime without permission, report your hours on a daily basis or a weekly basis, or however you're doing it, to make sure you're paying for the hours that are being worked. So if you have an employee who's notified by contact tracing that they have been exposed to COVID and they are quarantining, are they eligible for the FFCRA leave for the 2 weeks? That answer is yes. So it's if you're sick, if you're quarantining, or if you're caring for someone who's in that situation. That assumes that you're eligible for FFCRA, which is, again, those less than 500, or for those that are governmental. Don't forget, the FFCRA does allow assistance for you to pay this time to the person who is sick. It is done through taxes. And again, on that FAQ sheet on the Coronavirus Resource Center, you can get all of the details. But yes, if someone has to quarantine and they're being mandated to do so, then they are covered by the FFCRA for those time periods. All right, what other questions do we have? Anybody? I see one more about working from home, and I'm looking for my answer to that. I have an employee who has been exposed but is not showing symptoms. Should I allow them to work? So whenever you have an employee who is being exposed, you should always go in and check the current CDC guidelines. The current CDC guidelines say if you have someone who has had a true exposure, that means they have been within 6 feet of someone who was positive for COVID-19 for more than 15 minutes. So within 6 feet, more than 15 minutes, you actually should keep them home for 14 days because it can take that long for the virus to show itself. That is actually different and is longer than what happens if you actually have COVID-19. If you actually have COVID-19, then you're to quarantine for 10 days after your last day of exposure and that you feel any kind of symptoms. So that is the difference, and it's about how long they've been out. But the CDC, you should check it every single time because the rules that the CDC are putting out are constantly changing. But yes, if you have an employee who has actually had an exposure, a direct positive exposure, you should keep them home until they're out of that time period. What if you have an employee who wants to quarantine on their own because they are afraid? So if they are just afraid, that is not a legitimate reason for not working. If they have a disability, if they are in a high risk category, you need to do that accommodation metrics, and you need to do whatever the doctor tells you to do for that person. So for example, my father does not have a disability that has ever impacted his ability to work before. However, what he has is a form of pulmonary asthma. He is the highest risk category that you can be almost. And so his doctor is keeping him in his bubble. That person does get an accommodation. But if you just have someone who's afraid to go to work, then you do not have to quarantine them or give them any kind of leave. Now, whether or not you want to do so for employee morale reasons is a different question. But again, one of the big issues with being afraid to come back to work and making that accommodation is that you do need to consider how and when it's going to end. So is it going to end when we get a vaccine? Is it going to end when there's no more coronavirus? Who knows when those things are going to happen? So if it's just fear without a true exposure, that's a different issue. Now, if you've had someone who's positive at work, and that person had some kind of limited exposure to them, then you need to, again, look at the CDC categories. But just being afraid to go to work does not count. So what if an employee is tested positive for COVID-19 and their employer wants to know if they should quarantine or be tested? So it's very important for you to remember that if you have anyone who tests positive in the workplace, you as the employer should never disclose the identity of that person to your coworkers. So if I get COVID-19, my HR person, her name's Kelly, Kelly should not go around and tell everybody that Ashley has COVID-19. What Kelly should do is she should contact me, assuming I'm able to talk to her, and we should go through who I was around in the 48 or so hours before I tested positive. And let's get a list of those people that I was around. Then you should tell those people that they have been potentially exposed, and those people should quarantine. That does not mean you shut down your whole workplace. It is those people who have been in, again, a certain vicinity. And so you look at those CDC guidelines to figure out what that is at the time. Again, right now is that you were with someone in a 6 foot or smaller area for more than 15 minutes. Those are the people that you should be notifying so that they can quarantine, and they may want to get themselves tested. If the employee themselves let other people know that they have COVID-19, that's perfectly fine. As long as you, the employer, are not the one who's divulging that confidential health information, it's fine if the person wants to tell everybody, hey, it's me. And in fact, I think it's pretty rare for people not to know who it is that, actually had COVID. In my workplace, we've had 2 folks who've tested positive for COVID-19. At the end of the day, did we all know who they were? We did, but the workplace did not tell us who it was. The gossip circle did, but the workplace did not. And in fact, in both of those cases, the person actually said, hey, it's me. I started feeling ill on Tuesday. I was only on the 5th floor, and so they revealed that, but my employer did not reveal it. So it's about what the employer does. All right, I think that we have answered all of the questions according to Anna. I really hope that this was helpful to you all. Again, I encourage you all to go to that link that I put on the slides. If you just Google Ogletree Deakins, you'll see at the top of our website, it's called the Coronavirus Resource Center. And within there are a ton of great resources for the HR community. Again, the area that has our state and local orders will keep you updated on everything about the state and local orders that come out. If you want to know about what kind of litigation is being filed in your community, there is a litigation tracker that is available under the litigation tab. We are tracking these workers' compensation and liability shield statutes for you. So all of that is available for you for free under the Ogletree Deakins website. And if I can ever do anything for any of you in the future, please reach out. I hope this was helpful.
Once again, thank you, Ashley, so much. We really appreciate this. Ashley was able to answer all 10 questions today. If you do have any additional questions for her, please feel free to email me and I can forward those along to her. If you missed an answer to a question, those will be in the recording that will be sent out tomorrow. And now on your screen should be my email, anna@hrsimple.com. If you have any additional questions about today's presentation, HR Simple, the coupon code, please send me an email. I'd be happy to answer any questions. And below my email should be the SHRM and HRCI code so you can receive credit for today's presentation. Once again, thank you so much, Ashley, and have a great rest of your week, everyone.
Thanks, Anna. Thanks, everybody.